Okay, I want to welcome everyone that has joined us on time. We love you to the legal aspects of risk management and dispute resolution. We have our very own SCORE Boston mentors, Bill Hulsey and Kirsty Whitaker, with us to share what they know about this topic. But before we get started on that, I want to make sure that you know about all the resources that SCORE has so that you're taking advantage of everything that we offer. Our main goal is to share small business information, and we do that in several different ways. One is from our website, score.org, or our chapter, score.org/Boston. You will find just a plethora of information. You're going to find articles, podcasts, recordings, templates for marketing, business plans, financial statements, all kinds of things you can download, just tons of great information if you want to dig through the website there. The other way we share information is through our webinars and workshops. We share that or announce those through our newsletter. Of course, they are on our website as well, and we also post those to our social media. The most important thing or most important way we share our information is through our mentoring. And our mentors are volunteers, and they have had a variety of experiences and they have a variety of skills that they want to share with you. We're working with folks in the whole range from trying to decide if they should start their own business to planning that business to being in that business to exiting that business. So we work with the whole through with you for the whole journey on any business topic that you need. If you've never had a business mentor before, a first session will last probably about 45 minutes ish. And they want to know about you. They want to know what your goals, your challenges are, and they're going to work with you on a plan that you can use to overcome those goals and to meet those challenges. Now, um, if they need to invite other mentors, we have that mentor resource as your needs change along your journey to bring in, and you'll have a team of people that are behind you that want you to be successful. So, how do I get that mentor? There's many ways on the SCORE website to get a mentor. Probably the easiest is just to put your zip code in the zip code matching box, and that will match you to the chapter that's nearest you. There'll be a couple quick questions on how a mentor can help you, and we use that information to recommend the proper person for you to get started with. So, a little bit more about today. We are recording, and that recording will be available in 24 to 48 hours on the score.org/Boston website. You look on the blue bar as shown on the graphic under local workshops, and you'll find previously recorded, and that's where we put all of our recordings. We are absolutely taking your questions today. It is easier if you can put them into Q&A. That way I can keep track of those that are answered and those that are not. Sometimes if chat gets a little too active, it could be difficult for me to find those. But we will do our best to make sure we answer all the questions that you have possible. So I'm going to go ahead and turn it over to Bill and Kirsty.
Great.
Thanks, Teresa.
Thank you very much. Happy to see everybody, or not see you, but thank you for coming today. This is a topic we've presented regularly. It's an evergreen to the extent that there's always a need for people to think about how they're managing their risks. We obviously can't cover everything in an hour. So part of the goal today is let you know that Kirsty and I are here as resources as well as our colleagues, and we will cover some of those resources during the course of the presentation. Just let me say that I'm so grateful. I've been doing this for a few years, but Kirsty is a more recent member of the chapter and has really made this presentation just much more accessible to you and so on. So I'm very grateful to be having you join us here, Kirsty. I'll stop if you want to introduce yourself a little bit, and then we'll get going.
Great. Thank you so much. I'm so excited to join you, Bill. I have got so much admiration for you and your history and everything you've done. So thank you so much. It's a pleasure to be here. Just to let you know, I have recently joined SCORE here in Boston. I've been around the legal aspect and governments and dispute resolution now for 22 years. I am an actual qualified lawyer and I'm admitted over in Australia. I do not practice here in America, but my specialization specializations is dispute resolution and also international law. So around international trade in the international law area. I am also a qualified arbitrator. So Bill and I have had this conversation. I am very pro arbitration with disputes, but we'll get to
Yeah.
that later.
Yeah.
So, but no, thank you so much, Bill. I'm really
Yep.
excited to present this.
Great. Teresa, can I share my screen now?
Yes, please go ahead.
Oh, okay. Let me see. May I? Let's see if I actually can. Oh, there it is. And Teresa taught me how to go to slideshow. She kind of taught me how to go to slideshow. There we go. So I just want to tell you just right off the bat, this is so much more professional looking than it was. So I just to get started there is great. But here we go. Um, uh, yeah, there we go.
Now it's coming.
Yeah, for some
It's a little
reason
bit
it
slow.
takes a moment, but we will get there. All right. So as I said, this is Kirsty and I today want to work on and give you some basic fundamental ideas about how to think about risk in your business. All of you have risk at some level, and some of you may have a lot of risk if you're teaching children, if you're a massage therapist or something where there's physical contact. So there's a spectrum of risk, but everybody carries some risk in their business. If you're writing, creating intellectual property where there's a risk of claims of infringement, if you've got a trademark, and Kirsty and I were talking about that the other day. So, what we want to do is not overemphasize it, but make you aware of it and let you know that there are a lot of pretty robust steps you can take to minimize your risk. And the goal today is going to be to really talk about those and so on. Kirsty, what I thought I would do is I'll kind of cover the first part, and when we get into dispute resolution,
Great.
let you take the lead. Obviously, jump in if there's anything that you see
Happy
that
to.
needs adding. Does that make sense?
Fantastic. Perfect. Thanks, Bill.
Yeah, okay. So I use this. I don't even know. I'm so old that maybe they don't make three-legged stools anymore. But the idea here is to create for you a stable platform for your risk management. And I think of it in terms of three legs. One, you're probably familiar with these at some level, but one is your entity formation. Are you going to go as a sole proprietor and not have any entity interposed between you and sources of risk? The second one, which we'll talk about, is insurance, where we want to make sure you are having insurance as part of your business expenses. And then a third one that people often overlook is a lot of the things that you can do in your contract with your customers, or even when you're on the other end purchasing services, to make sure that your liability is limited and appropriate. So that's kind of the basic format for today's discussion in the first half. And then again, we're going to talk about some risk management ideas. So again, the entity, if you can afford an entity, it's there exactly for the purpose of limiting your personal risk and limiting the excluding to the extent possible the risk that you might have personally. We've got a legal entities workshop. We want to avoid that individual liability. And then, briefly here, we'll talk about two of the most common models. We're not going to talk so much about the tax implications of the C Corp and the S Corp election and so on. So today's focus, again, is to introduce you to these models, but in the context of your risk management. Let me see if I get that out of the way there. Okay. So the first one, I don't know how many of you are in Massachusetts or as opposed to neighboring states or elsewhere, but every state in the country has some form of the limited liability company. It's not a limited liability corporation. And the benefit is in the title. It's there to limit your liability. It's a cheap and easy way for you to establish yourself as a business entity. And by doing so, you make all your contracts and everything in the name of the entity as opposed to yourself, so that if you ever do get in a dispute, you're not personal assets at risk. There's some rules related to that in terms of making sure that you distinguish the assets of the entity from your personal ones. But as long as you play by those rules, you're usually in pretty good shape. It's a very easy process. I use the checklist at nolo.com. You don't have to hire them. We're here to help you through it. I've probably given this link to several hundred people literally over the past 8 years. And I think two people in that time have said, "Hey, I don't understand this checklist. Can you help me with it?" It's very simple, very straightforward, very user friendly. And of course, we're here to help you, whether you're going to set up that entity by yourself or if you're going to bring in some additional members. There is a cost, and I raise that in part because a lot of people want to set up the entity while they're still thinking about a business. And I try to tell people, let's save that $500. The first thing we want you to be doing is thinking about your actual business and your business plan, in part because your how you plan to capitalize your business may inform whether you go with an LLC versus a C corp, for example, if you want to issue shares, to capitalize yourself. So don't rush off to the Secretary of State and create the LLC and then realize you needed a different model, or maybe you're one of those few people who really didn't need to create any sort of entity because the nature of your business is such that there isn't going to be any meaningful risk. Just one little step here is that there is no taxation at the entity level. So if you're already in business and a sole proprietor, uh, when you move to a single member or multi-member LLC, you're not going to be taxed. If you're a single member, you'll continue to file your Schedule C. If you move to a multi-member, the IRS treats you like a corporation, but the taxing impact is going to be exactly the same in terms of no hit at the entity level. Let's see here. I can't get it to move down now. Let me try this one. Okay. So the C corp again is a way to distinguish the corporation from the assets and the liability for the individual. Again, if you want to capitalize by issuing shares, this is a way to do it. In most cases, the corporation is going to start with the expectation that the corporation will pay taxes, and then the shareholders will also pay taxes, or if they're listed as employees, they'll pay taxes on their employment income. There is an exception to that called the subchapter S election. Just a little footnote there. People often say, I'm an S corp. You have to be an LLC or a C corp first, and then you go to the IRS and take the S corp election, which puts you in a preferred tax status. But just remember, it's one of those. And again, we're here to help you and to discuss those things. And we always, again, want you to be grounded in the idea that, is my business entity furthering my business plan and not the other way around. So first things first, let's test the viability of your business through your business planning process, and then decide if it's better to spend that $500 if capital is short on an entity, or maybe some marketing or outreach or other, acquiring inventory or what have you. So that's really where, we want to come out of today with, if you're starting up, with having a conversation with us to really see where the kind of risk management stuff we're talking about today fits into the broader issue, which is your business plan, what you want to do, and testing, making sure that you've got a good plan in place. And then the entity itself will be self-evident. Insurance, I want everybody, insurance is a marketplace. So the insurance, the price that you pay, the premium that you pay for insurance is a function of the amount of risk and the size of the business that you're in. So it's always a deductible business expense for you. But almost anybody uh, can can afford insurance given the size of their business, and it's always good to find out and think about it, not because you're necessarily going to do something wrong, but because somebody may sue you. And so the point of the insurance is that it will be, as Kirsty laid out here more clearly than I did, uh, will pay for claims successfully made against you, but more importantly, it'll pay your costs of defense. So somebody uh, gets mad at you and they have the money to file a claim in court, and they come after you, and you call your insurer and they start to defend that claim. Even if you were 100% right, you end up avoiding having to pay those costs of defense. Subject to the next bullet, which is your deductible. I was talking to somebody the other day, a client who was in a kind of a risky business. He was doing some stuff that had the potential for uh, litigation. The kind of work he was doing required some warranties and so on that we'll talk about. And he said, "Oh, I've got X amount of insurance." And I said, "Well, how much is your deductible?" And he said, "What's the deductible?" And the deductible, or retained risk, as we have here, is the amount of money that you, as the insured, agree to pay before the insurance company steps in. So as you're thinking about it, and again, we can cover this in more detail in a one-on-one meeting, but if you're thinking about your insurance, you want to think about the limits, obviously, of your insurance, but you also want to understand how much of that you've retained as the deductible before you sign the policy, and understand what that risk is there. So again, I'm finding that markets are pretty efficient. There's a lot of online marketing now, and there are people that do things. I had a guy who uh, designed and tested medical devices. So, yeah, it's pretty high risk if you get it wrong. So his insurance policies were pretty high, but most of the people we see, the insurance policies are really quite reasonable, and they're pretty efficient. So, we're here to help you look at those policies. Ultimately, those are your commercial decisions, but we can help you understand what those terms mean and what you're looking at when you get a quote from somebody. So
Can I
again,
just add to
yeah,
that,
sure.
Bill, if that's all right? With the deductibles, the one thing too that I tell people, because a lot of people look at it with, oh, if I take a lower deductible, then my premiums are going to be higher. Or if I take a higher deductible, then my premiums will be lower. I always tell people that think of it as this. If you are in that position right now where you have to go to your insurance company, what would you feel that you would be most comfortable in paying as your deductible? Just because a $1,000 deductible will save you a little bit of money in your premium, at the time when you need to utilize that insurance, you might not have $1,000 there to actually pay that deductible. So I always tell people just to keep that in mind, because I do see a lot of people that go, on any sort of insurance, and they're like, oh, well, no, I'll just pay the higher deductible when it comes to it. I won't need it. There will
That's
come a
right.
time. So
That's such a great point, Kirsty. So thanks for emphasizing that. I mean, it's think of it like your car insurance, right? If you've got a $1,000 car, maybe you don't need to, you can have less deductible. But if you've got a 50,000 or $100,000 car, you don't want to have a $10,000 deductible, because those costs are going to fall on you. Again, we those are business decisions, but we're here to help you think about them, and even maybe more importantly, help you navigate the quote, which sometimes they can be a little confusing. But that's such a great point, Kirsty. So
thanks,
thanks.
Bill.
Hey, Bill, I have a question from the first leg, if I couldn't throw that out real quick.
Yeah.
When you say no hit at the entity level, are you referring to the business income tax or the self-employment tax?
Um, that's a great point. So the entity, you don't pay tax on the revenue to the entity. But if let's take the simplest example, that you're a sole member LLC. Obviously, if you're a sole proprietor, um, you're going to you're going to pay those quarterly estimated income taxes. And the same is true if you're a sole member LLC. And it's also true if you're a partnership. The one exception, and this is deeper than we can go here, but call me or Kirsty and we can explain this, is that you can classify yourself as an employee, in which case the entity is, and the LLC is going to pay those taxes as part of W-2 wages and W-4. So, they'll do the deductions and they'll make the reporting. But if you're taking the income out and not listing yourself as an employee, then you're going to have to pay those quarterly estimated to the state and the federal. Was that the whole question?
Thank you. Yes, thank you.
Okay. So again, we got a lot to cover. So this is just hitting the high points, but in addition to, this is an area that I think is often overlooked. You can get your LLC, you can get your insurance, and if you're lucky, you'll understand what the quote provides. But this is really, I'm going to mix my metaphors now from three-legged stool to tip of the spear, but this is the one that really you have the most control over, is the contracts that you're executing with your clients. And it's so many people get in trouble because they sign something through an online for their vendor or for their client, or they don't understand what's in the contract themselves, even though they had an opportunity to issue the document. So I really want you to think about, if you're in a business of providing services or goods where you have a contract that your client is signing, I want you to really do this, and I'll refer you later to a resource that we have about how to have us look at those and make sure they're right, or use one of our templates. But if you think about the basic structure of the contract, there's three kind of steps. One is, what are the risks that you can control? If you're promising to do something at a certain date to a certain quality, that's on you. If you're delivering something to another party that they're going to take and use or sell or add to another product or something, that's a risk on them, and that's a risk that they can control. And then the other one that's, more top of mind now than it used to be, are third party risks, are risks that neither party can control, like acts of God, acts of government. You remember during COVID, there was a ton of litigation and contracts that couldn't be enforced because supply chains were broken, schools were closed, people couldn't deliver the services because the school didn't have the children there to accept them, and so on. So those are your three categories, and we always want to make sure that your contract is addressing all of those. All right. So, and again, I'm going to give you a resource later here, but there are a couple terms that you always want to see in your contract, and these are the ones that are going specifically to risk. And the first one has to do with the scope of each party's liability. So you'll often see a limitation of liability clause or liability clause, and then you're going to see, related to that, just how much money am I kind of on the hook for if something goes wrong. And so here are just some of the steps, some of the things that could be create risk for you. I don't think I can move my cursor, but you can see them. I'll start at the top and move left. Your delivery timeline. What happens if you promise to deliver something and for some reason you can't get it, and that it creates damage to the client, and they can't deliver the ultimate product, or they can't sell it when they wanted to. If you're delivering Christmas or seasonal items and you deliver them in January, then that's not really a valuable product anymore for your client. Ownership of IP and work product, that's kind of a two-edged sword, and it's really a topic on its own. But if you are hiring people to create content or do research for you or so on, you want to be thinking about what they're delivering to you and your ownership of that. And obviously, sending it downstream to your client, the same discussion needs to occur. And then the risks of people, third parties, claiming that they've been infringed upon. So if you're in a field where you're creating uh, intellectual content, you probably want to attend to these clauses and give Kirsty or me a call. We've got some other IP folks as well, so we can help you understand that better. Payment schedule, we see a lot where the our client is working for a bigger client and they're subbing out some work to vendors. So one thing you want to do, for example, is just say, I'm not getting paid. You're not getting paid until I get paid. So you want to make your payment schedules kind of congruent with the payments that are coming, to the extent they're dependent on payments from our clients' upstream vendor. How to deal with change orders. One thing we like to emphasize, and you'll see this down below, is having very detailed scopes of work, or statements of what's going to be delivered and when, because you don't want there to be ambiguity there, because that ambiguity can lead to increased costs for you, dissatisfied customers, and so on. And then, as Kirsty stuck here, part of that is making sure that if there is an iterative process where you're delivering something and then the client has to sign off, and then before you take the next step, that you've addressed that approval and change order process uh, in your written document. The old saying, of course, is that an oral contract isn't worth the paper it's written on, and that's kind of why, because anytime you've got an oral contract, you're going to have a dispute sooner if things don't go well. So the scope of liability is just an opportunity for you to really lay out who pays for what. One thing is, if you're creating a product that needs to be delivered somewhere, who pays for the costs, related taxes. We were talking before we came on about tariffs, and related expenses of getting a product out to your client. You need to address all those hidden expenses. Again, changes in the scope of work, ownership of the IP. People don't pay attention to this until they need to, but then it's typically too late, and people are at minimum disappointed. So, and then things like two that we'll talk about in a little detail here: what happens for errors, what happens for damages. But the other two, and these are especially if you're dealing with bigger companies that tend to have boilerplate language, are indemnification and your warranty obligations. So you want to make sure that these things are clear to you and that you're understanding how much risk you're taking on when your client, or even if you're hiring somebody else, you're looking for a warranty. So a warranty is a promise that the service will be performed to a certain standard, or the product will meet agreed to specifications. And again, this is why our model, we encourage you to we like to have a master kind of service agreement that has all the boilerplate, but then we attach a specific attachment that's either got the scope of work and the timeline and the deliverables, or it has the real specs on what's product or good is going to be delivered, and what timeline, and again what the approval process is. Because people are excited. We're small businesses. We want to get out there and get the work. We want to get our payments flowing, and we want to make the customer happy. So we tend to shy away sometimes from this kind of language, but it can come back to bite you. And depending on the size of the contract, it can be a pretty severe bite. In terms of intellectual property, again, if you're creating content, if you're an artist, if you're doing web designs, if you're doing all kinds of stuff, there's a lot of people out there who make their living suing for alleging intellectual property violations. So You
And it's
never make
expensive.
absolute promises. That's why I put, have your warranty with regard to IP be to the best of your knowledge. You don't know what's out there in the world. And again, these are just some high points for you to think about, but an indemnification, just moving on and trying to stay on the schedule, is your contractual obligation to pay your client. We'll say we'll pay the other party if certain things arise. And a lot of times people want, and it's kind of the sister to insurance, and the person that's doing the indemnifying is kind of acting like an insurer to say, if this thing happens, then I will give you X amount of money, or I'll cover damages that are related to the thing that I should have controlled differently. And that's why I teased this out in the beginning with saying there's three levels of risk here. And the one that you want to think about in terms of indemnification is who's in the position to control the thing that might trigger the indemnification. So if it's you, then maybe it's fair to say, well, I'll indemnify you, putting aside how extensive that's going to be. But if I'm going to give you something and then you're going to change it or modify it or add it to another product or combine it with a different service offering, then that those changes are in your capacity to control, and I'm not going to indemnify you for those. So again, you only want to assume indemnification responsibility for the things that you can control, and obviously you don't want to indemnify for anything that's out of everybody's control, like a force majeure event. If the product can't be delivered, if the service can't be provided because of COVID or an epidemic or some other thing, then that's not your fault either. So we want to, again, we can't teach you the whole field, but that you just want to be thinking about what can I control, pardon me, control, and make sure that my indemnification and even my warranties are kind of congruent with that first point. And again, these things are not written to be user friendly. I had a client several years back that did software as service, big projects, big dollars, and so on. And I remember going to their, one of their lawyers and saying, I can't even understand what this means. How do you understand it? And when they started talking to me about it, they realized that they had included a phrase and then included its opposite so that the two canceled each other out and they weren't getting what they wanted. But it had just been boilerplated for so long. So these are hard to understand. You can always ask us to help you understand what they mean. We can't be your lawyer, but we can explain to you what they're asking you to take on and maybe offer for you some alternatives. So in the second box here, and this goes back to the concept of being an insurer. You don't want to be if, indemnifying if you can help it for just mere negligence. You want to try to kick that standard up to where you're saying that something was intentional or willful or gross. That's a good way for you to protect yourself, as opposed to, you know, whether you had some duty that you breached, which would be the negligence standard. So again, just if you see indemnification clauses or you want to have one in your contract, you really just want to um, get with us and check this resource we're going to talk about in a minute. Um, and make sure that you've got good language there. The main point here, and I'm a little wanting to make sure, Kirsty, that I have given you enough time here, but
No, you're
um,
fine.
the big question is, I'm just going to skip this and go to the next one, is you want to think about your liability in not only in the context of what you're in a position to control and what you're not in a position to control or prevent, but also the scope of the job. So if you're delivering $1,000 service to somebody, you don't want to take on $1 million worth of liability under any circumstances. And an insurance company, if you think of it, wouldn't do that either. You know, they're going to calibrate their premium based on the amount of risk they think and the likelihood is that they would have to pay out. So think about this liability in the way that we started this, and think about it in terms of the size of the job. If you have specific terms um, that you want to review, when we get down to the end, we're going to give you some resources that you can connect with. But I think unless there's some questions, that's a good stopping point for me, and I'll hand this over to Kirsty.
Thanks, Bill. Can I just add on to
Yeah.
what you're saying about risk? I do what I do in my business every year when I go on, every 1st of January, I take a look at my business plan just to make sure it's
Mm.
accurate. But also, in part of my business plan, I have a bit of a risk assessment, which is
Oh,
where a lot of people I find when I'm going out, government and small businesses included and alike, they don't want to identify risk because it's scary. It's scary
yeah.
knowing that, this could actually happen. This could blow up. But the best thing about identifying risks is that you can sit down and you can say, that could happen. And if it does happen, I could do X, Y, and Z. You can't premeditate what you're going to do in that situation because it hasn't happened. But at least if you have some sort of idea or plan, you can have a look at it and go, that could happen. I need to go and see a lawyer if that happens, or I need to go and do this if that happens, or if this happens at this point, this, and this could happen. So I do a risk matrix and a risk assessment as part of my business plan review. I just tick it off and I just go through and that's it. And I find it keeps me on top of things. So I think it's great. I love identifying risks.
You're
I
not a
like
put your head in the sand kind of gal.
no, hit it straight on.
Yeah.
Yeah.
So Kirsty, if you want, just tell me when you're
Excellent.
ready to change slides, and I
Perfect.
think that'll be easier than me switching over to you.
Okay, fantastic. Thank you. Thank you again for letting me present on the dispute resolution side of today's workshop. I love dispute resolution for a couple of reasons because one, I did do litigation, and I litigated back home in Australia. But two, I think there's other approaches that we can look at, especially for small businesses, so that it doesn't go to litigation. Litigation is scary, it's expensive, it's stressful. And I'm telling you now, there are so many pre-steps you can do to try and avoid it. So, what is resolution, dispute resolution? It's when a conflict comes up. Why does it matter? Dispute resolution, one of the biggest things is when you get to that point and you have a contract where you have a disagreement or someone says, hey, you didn't fulfill this, you want to try and protect that relationship because, your contracts are important to you, your reputation is important to you. So this is why you want to try and do dispute resolution before you turn around to somebody and go, oh, well, if you're not happy, just sue me. Don't ever say that. So what we want to do is we want to avoid that. Now, with dispute resolution, there are a couple of other means. You have mediation, which mediation is where both parties will get together with a mediator. You can go and get you can actually get a free mediator or you can pay for a mediator. And it's where the mediator will sit down and say, okay, well, side number one wants to do this, side number two wants to do this, and they try to get you to meet in the middle and have an agreement. Mediation isn't a legal binding agreement. So if you go back on that agreement, then the other party can keep pursuing you for it and vice versa. Um, then you've also got arbitration and you have litigation. Now, arbitration is what I specialize in. It's not, I find arbitration, and correct me if I'm wrong, Bill, but not a lot of people actually really are aware of what arbitration is. A lot of people definitely know litigation and mediation, but not so much arbitration. So, what arbitration is basically it's where you go to a body, which is like a mediation or arbitration body and a council, sorry. And what they do is a mediator will sit down, you submit your papers to the mediator, another person, or sorry, the other side will submit their papers to the arbitrator, and the arbitrator will then assess what their findings are on the case. Now, that is a very broad way without going into detail of it. Arbitration, look, you can, most of the time you need legal representation unless you know what you're doing. So you still have to have a lawyer involved. The other side still has a lawyer involved, and it can actually rack up a lot of costs, as Bill actually pointed out to me because we were talking about this the other day, that it can rack up a lot of unnecessary costs for you as a small business, especially if you're only arguing over something like $1,000. So while arbitration has its pros and cons, it can actually be costly as well to a small business. What the pro is to arbitration is if the arbitration is run correctly. Now, there's many different ways of what correctly is, so I won't go into that today. But if arbitration is run correctly, then the actual findings, they can't appeal, and you can enforce them in a court. Now, I do say that with the precursor of it has to be done correctly. I'll give you a bit of a case study at the end if we have time, but again, it's a very strict protocol that you have to follow with arbitration. Now, litigation, everyone knows what litigation is. It's where you go to court and, you say this person owed me this money. The court say, the other side says, no, I don't. And the judge makes a finding. Now, the problems and the pros and cons with litigation is, I, well, actually, I don't really see any pros to litigation, except us lawyers make money out of it. But but no, the cons of litigation is your relationship is going to be ruined with the other party. And you want to try and preserve that. Not only that, too, I've been in litigation cases where we can see the facts of the case, and we can actually sit down and we feel confident that we have a strong case against the opposition. However, the judges ruled in the opposition's favor. And, that is pretty devastating. And then it goes to appeals and things like that. So with litigation, it's time consuming, it's costly, it's so confusing as well. I always try to get people to avoid it. I do love being a good litigator, but I do get people to try and avoid it at all costs. So that's just a little bit about the three different types of resolution that we have. Again, dispute resolution, the biggest thing that I think that this comes down to is communication. If you can communicate and try to negotiate at the start of it, then you can actually avoid a lot of this, and you can still keep that relationship intact. Okay, so sorry, I've gone on a little bit longer than I should have with that slide. Bill, do you want to flick to the next slide for me? Thank you. Okay, as I said, negotiation and communication, I would say, are the most important things to do. Now, I am in business as well. I have had many contract disputes. When you've been in business for 22 years, it comes up quite often. Now, again, I've also, been part of the legal teams with many contract disputes. When you have a contract dispute as a small business, and, like I'll be very raw here, it's really scary. It's so scary when the person that you're dealing with and you think you've done everything right and they come to you and they say, "Hey, we're not actually happy with your service." I've seen a lot of people that will stick their head in the sand and they will stop communication altogether, and then it just goes to unnecessary courts. I really do firmly believe that if the other party also is willing, if you can just approach it and say, I'm really sorry you feel that way. Can we have a discussion about this? You're not going to want to have the discussion. It's going to hurt. You're not going to be happy with it. But if you can have that discussion with the other party and be calm when you have that discussion, then, most of the time you can avoid any disputes going forward. The other thing too that I notice a lot with people who do start the negotiations and communications is that they're very hot-headed. And I think actually I just saw a comment pop up about the emotional toll. Yes, the emotional toll, and I'm hoping that that comment was around about what I'm about to say. But if you go in very much into a negotiation and go, nope, I'm not budging. I did everything right. I don't care what you say, then you might as well just go to court because it's not going to work. Negotiation is all about give and take, and same with communication. So, you're quite honest to the other side and say, well, tell me why you don't think that I met these standards. And then you go, okay, well, can you give me some examples? Or can you, like, I thought I did this, this, and this. So, when you are going into negotiations, just be open-minded about it. Take out your anger and everything beforehand or afterwards, but be open about it. Sorry. I can see Bill's laughing there. I'm a crier. Okay, when I go into negotiations and I'm talking to somebody, I will burst into tears if it's my business. I know how the emotions can run. But look, this is just a little bit of a step-by-step way of, like why to start negotiation, the key principles of effective communication, when to use negotiation, and just a little pro tip there about document any agreements. Look, as I said, communication is so, so key. I have a client, and as soon as they get any correspondence from a client of theirs where the client isn't happy, they literally block them on their emails. They block their calls, they block their emails, and hope to goodness that it will just disappear. And I can tell you now, it never does. It gets worse and worse for them every time they do this. So don't do that. Please, communicate. But when you do actually make any discussions, and if something does pop up, I always tell people when you're actually having that discussion after you've hung up the phone or after you've left that office, always follow it up in an email and say, thank you so much for meeting with me today. I just wanted to send you off an email. This is what I understood as the outcomes of this meeting, etc., etc. And then that way, you've told the other side how you've seen it. They might have walked away with a different impression. That's where they can come back to you and say, actually, we thought it was this, or yes, we agree. But just always make sure, as Bill said before, a contract that's verbal is not worth anything. Always follow it up. And yeah, it just helps. All right.
Kirsty, one
Yep.
thing I'd add is just in terms of the emotional content, there's a great book called Getting to Yes. It's been around since the 80s. But you should have that book on your bookshelf when you're negotiating or having a dispute with someone, because it's a way to help you put your personal issues and your emotions aside. And if you can get the other party to play along with that method, it reduces the emotional tone and the
Does.
emotional temperature. So
Oh, it's so true. And I agree with you. I
yeah,
think that book everyone should get.
yeah. Shall I go
Yep.
on?
Yes, please. Next slide.
Oh, come
Just want to move.
on. I don't know. It works
Sucker.
sometimes and not. Kind of like me, I guess.
Like me as well. While you are trying to move that to the next slide, can I also just say tone and mannerism when you are talking to somebody? Really does go a long way.
Yeah, I don't know why I'm stuck here. I'm sorry.
No, you're fine. I can just keep talking anyway. No, tone and mannerism when you're in there. So just remember
Is
that as
that the
well.
best one? That's next, I think.
Yes, that's the next one. So again, mediation, arbitration, and litigation. So as I said earlier, mediation is that voluntary process where you do get that neutral party involved. With some of the mediation councils, you can get some free mediators, or majority of them are paid, from what I know, and from what I've seen. But the mediator just comes in, both of you could be sitting in a different room or literally online these days, and the mediator will just say, look, side A feels like this, side B feels like this. And then the mediator will just go backwards and forwards until you can hopefully reach a decision. Now, mediation isn't binding. So whatever, happens in mediation, you don't have to stick to it. The other party doesn't have to stick to it. Um, so yeah, it's not a legal binding decision. It's just something that a commitment or a promise to each other where you feel like, you can uphold. Any discussions with that mediator are always confidential, which means that if for whatever reason you end up going to court after this, the mediator can't be pulled in as a witness, and that mediation process won't be discussed. So that's mediation. Arbitration is like litigation. The result is binding on parties. As I did mention too, it can be quite expensive. The like there's a WIPO example that I like to use. WIPO is the World Intellectual Property organization, and they have what's called a domain court, and also Oh, sorry, Jessica, I just saw your question. I'll answer that in a second. WIPO has a court over domains disputes or trade disputes or things like that. Now, with WIPO, you can actually represent yourself. And the reason being is I had a matter in front of WIPO before I actually became a lawyer. And I looked at representing myself and I thought, yep, this is quite easy. I didn't end up representing myself because I didn't have the confidence to do it. And I ended up going to a lawyer, and this was quite a significant matter at the time for me. When I saw the lawyer and I worked with the lawyer putting together the papers, I can tell you now, having that legal representation because the other side wasn't represented, you can see the difference, and you can see how your your side is articulated, and it's done in the proper format. So with arbitration, yes, there are some courts there where you can represent yourself. My recommendation is always get legal advice before you do that, and always get a lawyer to hopefully help you. Again, that's where this all adds up to being expensive. So, when you go to arbitration, you have the arbitration fee, then you have your legal fee. So, if this is a dispute over $1,000, it's really going to be a pointless exercise. I would not go to arbitration for that. Comment about if an arbitration is appealable. I think that the question was, sorry, Jessica. So look, if an arbitration is done correctly, there are so many elements to it being done correctly, then yes, it cannot be appealed. It just goes to being enforced. Now, when I say if it is done correctly, I am going to use this is a case at the moment that I use in every single one of my case examples. Fashion Nova. For those of you that know Fashion Nova, if not, it's one of those quick fashion online platforms. They actually had a clause that was written by the in-house counsel at the time saying that all matters had to go through arbitration and could not be litigated. Then they had another conflicting clause that was literally right underneath it, which said that matters could be litigated. And look, I'm just giving you a high level overview here in layman terms of those clauses, not the actual correct technical clause that they had written in there. Now, basically, a person started a class action against Fashion Nova for false advertising. They took it to litigation. Fashion Nova thought, yep, great. I've got an arbitration clause here. We don't need this. This can be kicked out of the courts. It's not in the court's jurisdiction. Courts came back and actually said, you've got two conflicting clauses here. And because of that, we're going to allow the party to litigate. So then, they thought they had an arbitration clause, but it wasn't actually written correctly. And that was what got the actual arbitration thrown out. So I have seen it a lot. My biggest recommendation is I specialize in arbitration. I have done a lot of study and critiquing when it comes to arbitration and writing those clauses. If you are going to have an arbitration clause in your contract, and we're talking about a big dollar contract here with an arbitration clause, make sure you get a specialist that specializes in that field to write the clause properly for you, because that is the biggest thing. If it's conflicting, it can actually be it can either be kicked out of arbitration and litigated, which is going to cost you so much more, or it can actually be appealed on the grounds that there was no jurisdiction for the arbitration. So yes, you have to just make sure that is really written well. And again, litigation. So litigation is the formal court proceedings. So basically, an arbitrator is very similar to a judge. They both make a decision in that sense. The decision, then is either enforced or in litigation. It can be appealed, where then you go through that appeal process. Appeal process can be quite costly if you're doing it. Again, if it's only for $1,000 or something quite small, don't bother appealing, just go with whatever the findings are. But the biggest thing too that I would say to people is when it comes to litigation, if you're at that point where you're going to go to court, have a look at what the value is of what you're going to fight for. Because with litigation, the courts are backed up and it's a long process. Um, it's here we go. This is my comparable table about this. Um, the litigation, you've got high lawyer fees if you get lawyers involved. If you go to small claims court, I can tell you, I have been in small claims court here in Massachusetts, and it took over 6 months for my case to actually go to court, and then it took another 6 months for the judge to actually make a decision. And by that point, 12 months had passed. Literally, I could have made that money, 3 times more with a different client. So just sort of like assess the situation before you go jumping in. I do understand there's nothing better than going to court and saying, hey, I sued you and I won. But in reality, it's not like that. Can I also just say too, it's not like what you see in the TV shows. When you see the shows like Suits and everyone goes to court and it's done and it's settled immediately, it is not like that, even slightly. So,
Kirsty, I'm just wondering, in the
yeah,
interest of time, it looks like
yeah,
there's quite a few
yes,
questions.
I
Do you
can
want
see
to
that.
see if
Yes,
we can
yes,
tackle those? Because I
yep,
think these turn off at noon. So, I
sounds
mean,
great
in
to
an hour.
me. No, that's
Teresa,
fine.
I'm going to stop share and maybe you can read out the
Uh,
questions.
well, we don't actually have any questions. They were just
Oh,
comments to what was being said
oh, okay. So
during
we
the
can keep going
presentation.
then.
Yeah.
Carry
Yeah.
on then, Kirsty. Carry on.
Okay. Well, does anyone have any questions for the last 5 minutes? Because I feel like I've pretty much talked through all these slides with dispute resolution. If anyone has any questions, you just jump in and start asking. Um,
Payments piece. She has a question about the payments piece. I don't know if that was something that was submitted earlier in the chat. Oh, how can we be more effective with that
that's a hard
payments
one.
and contracts? Yeah.
Like before Bill jumps in here with that, because I know Bill's going to have a great answer for that. I understand. I did see one of your comments pop up earlier about the area that you're in, Jessica, and I do understand that's really quite difficult. I always tell clients take payment or take a deposit before anything, enough of a deposit that it will cover you for any out-of-pocket expenses. Because yeah, it's so hard to chase something after the fact. Sorry, you go, Bill.
Well, I think that's just right. And if you look here, we've got John Ballinger and I developed a suite of contract templates, and obviously one of the issues is payment terms and so on. You don't want to get out ahead of your expenses, and your costs need to be kind of aligned with the payment schedule. The last thing you want to be doing is chasing a client for payment, because then that goes into one of these processes. One thing I was going to mention, Kirsty, that you may not know is many of the state and state superior court and district courts have free mediation services. So you can go and say, God, we don't really want to bring this to court. Can you help us? And they offer that. So, you can always try in your county or your town and see if they have a mediation service that they'll pay for to try to get the matter resolved. But
That's
that's it
great.
from me, I
Yeah.
think. Any other thoughts? Call on John. You've got his stuff there. You can self-schedule with him if you go to the websites, and obviously me and Kirsty. We are happy to help you. Don't what was it? Don't put your head back in the sand. Don't
No.
ignore these things. It's
Address it
better. Let
beforehand.
us fix it. Let us do it once. Um, let
Yeah.
us do it right. And then, you'll reduce your risk in terms of somebody not paying you, or what happens if there is a dispute. You'll have addressed all that. And that's such a great idea to do an annual risk assessment. I
Yeah.
had never thought of that, but I think especially for a small business,
Yeah.
that's a tremendous piece of discipline to add to your back end work.
Yeah.
So what a
And
great
it's a
idea.
once off, have a look at it, review
Yeah.
it and just make the changes as you need to.
Yeah.
Yeah. Excellent. Well, thank you so much, Bill, for having me. I've really
You've
enjoyed
done it.
this today.
Well, we'll do it again. Any
Yeah.
other thoughts, folks? Otherwise, I will stop sharing and we'll be back with Teresa here.
Yeah, I think we're at an end. Thank you, everyone, for joining us today. And you have our contact information. Reach out. We're happy to help. And have a great rest of your day, everybody. Thank you.
Yep. Bye-bye.
Bye.